Well, thank you, Paige. This is Robert, and on behalf of Laura, Joe, and myself, I want to welcome you to our program today. Well, this program came about after I met Joe at a recent CAI law conference where the Berg Simpson firm had an exhibit table, and in chatting about the different ways we were helping community associations, we realized there were some important decisions and treacherous mistakes that boards and management could make with respect to reserve planning and construction defect litigation. So coming to realize that we had some important lessons and insights, we want to have a forum to be able to share those and help associations have a smoother journey through this challenging process and avoid the most common mistakes along the way. So we decided to see if we could schedule a webinar together where we could share some of these principles to help associations through this unfamiliar and potentially precarious path they travel when addressing construction defects. But before I jump into today's material, let me remind you that this is a live presentation and everyone's been muted to keep the background noise to a minimum. But we are used to speaking to a live audience, so to get your feedback every once in a while, we may ask you to raise your hand by clicking on the hands raised icon in your control panel. It looks like the one you see on screen. So locate that. And if you came with a question, or if at any time you have a question that arose due to something that we've said, just type it in the dialog box in your control panel, again, similar to the one that you see on screen. Paige will be monitoring that through our session today, and we'll select from those at the end during our Q&A time. I hope you're taking some notes. Over half of you have indicated that you're involved in construction defects at your association. But like all our webinars, we're recording this session, so it will be available on YouTube and on our websites for future playback. Another resource that I want to point out is an outline of today's program that we'll send to everyone who fills out a brief survey at the end of today's session. We'll be compiling all the questions from the first session and this session, and so please fill out that survey and we'll get answers to all the questions in that outline that we prepare. And as you fill out that survey, make sure you add some comments about what you'd like to hear in future webinars. We want to be sensitive to the topics you feel are valuable or important. So let's give this a test. Grab your mouse and click on the hands raised icon in your webinar control panel if you're ready for me to get going on the presentation. Hands raised, everyone? Oh, very good. Excellent. Okay, I'm going to click hands down. Thank you. And let me start out. Laura, what's the problem here? What's the primary issue that needs to be solved?
Hey, thanks, Rob, and thanks everybody for joining us today. We're really excited to present this program to you. You know, it's funny when you ask that question because the first thing that comes to mind for me is that being a board member or a manager in a community association really is a thankless job most of the time, right? And I think it gets even worse if you are confronted with property that has poor construction, whether that be the materials or the quality of the construction itself. It's not up to standards, and it's certainly not meeting the residents' expectations. Because at that point, then, the board is asked to do not only all of its other responsibilities like collecting assessments and maintaining the property and enhancing and doing more programming at the clubhouse. Now the board is asked to go above and beyond that and to really protect the rights of the members and to address these larger issues. You know, for example, let's just say you're talking about asphalt within your community. You know, you could probably expect 20 to 25 years before your asphalt would need to be redone, right? So that means you got lots of years to enjoy it, and you also have lots of years to reserve for it, maybe 25 years. So during that time frame, your board is likely to do some reserve planning and get some recommendations of maybe the cost to resurface after 25 years is $100,000. Well, that allows your board over 25 years to save approximately $4,000 a year. Pretty straightforward, right? Well, what if your board, however, is confronted with a little different type of timeline. Here you have a situation where you've got quicker deterioration for some reason. Maybe it's because the drainage isn't properly done. Maybe it's because the asphalt itself wasn't applied properly, or it wasn't at the appropriate depth levels. What's happened? Well, the board, the association is experiencing faster deterioration, more repairs, and all of a sudden they're faced with, wait a minute, we're not going to be able to just resurface this in 25 years. We're actually going to have to replace it sooner, maybe in the next 5 years. So now you look at the cost. Well, instead of resurfacing, now we're talking about rebuilding. Maybe that involves redesigning it, doing new drainage, basically reconstruction from the ground up. And instead of $100,000, it's now $250,000 in the next 5 years. So now your community and your board is faced with, how are we going to come up with $50,000 a year? The first thing I'll tell you is that your reserves are not going to be an effective remedy to address this type of a construction defect problem. And the owners in your community, however, are going to expect you to do it. They purchased their home with a valid expectation that the assets that were within it, whether it be asphalt or roofs or siding or any of those things, would last their normal lifetime expectancy. And they also expected that they wouldn't have to pay out of their pocket for things that were not constructed properly. They might have understood they had an obligation to reserve for future needs as things wore out, but certainly not to have to pay additional for something that just wasn't done right to begin with. So boards then are faced with, okay, we've got to look at some other solution besides reserves. And that usually involves investigating whether or not there's been some type of defective product or defective construction used, and then pursuing a builder or developer and looking to their insurance to correct and make the association whole.
Okay, well, that's great. That summarizes the problem. Now, the issue is, how do you get to the resolution? And what actually does success look like when you have this conflict and you have these big problems in actually a relatively new association?
Ah, so you want me to pull out my crystal ball, huh? If only it was that easy, right?
Yeah. Well, at least you have a crystal ball. You've used before.
Well, I do have a crystal ball. I'm not sure it works, but I can tell you what I've learned over the years, and that is that what we're really looking here in terms of success on behalf of the association is being able to restore the property to something that was properly constructed. Right? It sounds pretty easy, but it's not just that. It's not just properly constructed. It's also considering all of the external stakeholders and how they're going to measure success, whether that be courts, whether that be your individual members, whether it be other property owners, managers. And so you want to look at all of those external focuses when you're measuring what your success is going to look like. You know, because every decision that every board makes really must be done in the best interest of the association. And that's not black and white. There's no manual when you get on the board that says, oh, well, if this happens, then you do X. So making successful decisions, particularly when faced with these kinds of issues, really involves boards saying, okay, we don't want to make a foolish decision. We want to get our little measurement tool over here in the green. And that's what we're going to talk about today, is we're going to talk about the board's responsibilities and kind of the 3 standards that boards are required to look at in terms of being successful. The very first one is the obligation to protect, maintain, and enhance the association's assets. Where does that come from? That comes from the association's governing documents, right? Usually the declaration and the preamble has some language that mirrors this. And really what we're saying here is that the board must think about the assets of the association, protecting them protecting those assets, whether it be financial assets, the property itself, maintaining as well as enhancing certain things. The second standard is to follow the business judgment rule. Now, the business judgment rule, many of you have probably heard about it before, is a theory of law that's been developed over years and years by cases. And all 50 states have some form of the business judgment rule. It varies a little bit, but it's basically the same. And what it does is it protects the board from unreasonable challenges and liability for the decisions that board members make, so long as they follow certain requirements. It means basically nobody's going to come in and Monday morning quarterback your board's decisions. We're going to talk about this a little bit later, but let me mention the third standard that the board has to maintain, and that is making sure that it complies with applicable laws. Every state has unique requirements that might govern such things as your reserves, litigation, when can you litigate, how can you litigate. Joe's going to talk a little bit about that later. Even the duties of the board. So it's always important that an association consult with their local attorney, somebody that's experienced in community association law and construction defect law, as they think about how can we successfully craft the right solution to our community. So let's go back a little bit and talk about that business judgment rule. The business judgment rule has 3 prongs. And the first one basically is that every decision that is made by a board must be done in the best interest of the association, not the best interest of an individual owner, not the best interest of the board, but of the entity itself. In other words, for the whole. The second aspect is that every decision must be made in an informed manner. And that means that the board needs to make a reasonable inquiry. They need to understand what they're deciding. And usually in the context of reserves and construction defect, like we're talking about today, that means using experts, people that can help the board make the decision, that can educate them based upon their expertise. Then the third leg, so to speak, of the business judgment rule is that the board must have the authority and power to make the decision. In other words, they have to do it in good faith. And that authority and power comes from the governing documents and or from state law. So really success in this context means that the board is acting reasonably in terms of managing the affairs of the association pursuant to the governing documents, the business judgment rule, and state statutes.
Hi everyone, this is Joe. I'm going to jump in here now. You're looking at the Leaning Tower of Pisa, and so let's envision your association with construction defects or physical problems at your association, and the quality of what your owners now own and live in is not what was represented or promised to be at the time they purchased their homes. There is a well-worn path that an association through its board and manager can follow to ensure the greatest chance of success in that construction defect litigation. Is it simple? No, there certainly are a maze of problems that are going to come in front of you and your attorneys along the way, but there is an effective process that a board and its managers can follow to maximize the chances of a successful resolution. And that path really involves ensuring that the association and its board are meeting their responsibilities to protect, maintain, and enhance the assets of the association. And one of the most critical ways of doing that is to reach out for expert help, including through an experienced construction defect law firm with a proven track record of success in similar cases, so that the association knows it's headed down the right path. But ultimately, that really brings us back to considering balancing priorities at the community throughout this long and arduous process. We have the priorities of a successful outcome, as well as the priorities of continuing to maintain and manage the association in the manner that Loura just described, really falling back to that business judgment rule. So while we may have a roof that's leaking, a facade, say a stucco system that may be falling off or has significant problems that certainly all need to be addressed and dealt with, the association also has its normal bills, it's got its utilities, its management, its insurance. All those things need to be continued to paid throughout the process, and the property, particularly those areas of the community that may not be affected by the construction defects or the repairs that would be needed, those areas still need to be maintained. For example, keeping the entry gate system working properly, repairing boilers if those are part of the association's responsibility. And the board ultimately still has the responsibility throughout that process to look after the long-term care of all of the assets of the association, including those not involved in the construction defect litigation that's gotten going. So what do we do in terms of defending the association's rights now in terms of the construction defect litigation and continuing to properly and responsibly manage those ongoing needs and the costs of the normal wear and tear and deterioration of a community? Here, one of the most important things to recognize is that there is a clock that's ticking from the outset. Once construction defects show up or become known to an association, there are things called Statutes of Limitations and Repose. We'll talk about those in a little more detail later, but basically they can create very short time frames within which the association needs to commence a construction defect lawsuit in order to protect the association's rights. Waiting too long could cause the association to be unable to successfully pursue that construction defect litigation towards a meaningful resolution. Again, throughout that process, you've got the ongoing needs and requirements of the association, so your boards are going to be dealing with divided priorities. One, they're being pulled aside or pulled away to deal with the construction defect matters, while at the same time having those day-to-day, week-to-week, month-to-month responsibilities of the overall association's well-being. This, again, is where competent construction defect attorneys should come to you with an approach that will not only streamline the entire process as much as possible. There are certainly things that can't be controlled in the litigation context, but also importantly would help to minimize the requirements or the time and effort burden put on the board and the manager by the construction defect litigation itself. The idea being free up the association's board and manager to focus on those other non-defect issues, continuing to meet the responsibilities to properly maintain and oversee and manage the association. Clearly, construction defect litigation and defects themselves are a big deal. They are a distraction to the board, but at the end of the day, defects are not an excuse to let the association deteriorate as a whole or an excuse from doing things that have to be done yearly, filing annual tax returns, or just providing for the normal annual maintenance of the association. That also would include reserve studies. We'll talk about that a little more as we go through, but certainly reserve studies continue to be an important part of the board's ongoing normal operation and maintenance of the association. All of that needs to be handled. The board wants to keep its eye on the big picture of making sure that everything is headed down a successful path. So in terms of the deterioration that an association may face, we've simplified that to these three buckets here. You've got your normal wear and tear or deterioration. That, of course, falls within the reserves and the reserve funding. And really, reserve studies, like I said, continue to be critically important to the association. Reserve funds should basically be set aside at roughly the same pace as the assets within the community are deteriorating under normal wear and tear conditions. The middle bucket there is the surprise. So that's the insurance claims that may come up. The hailstorm that comes through and destroys roof shingles or maybe vinyl siding or vinyl windows. The windstorm that blows trees into a building, or the over-anxious driver who ends up backing into the entry gate or some other part of the community. As long as the association is adequately covered through its insurance, really that solution is through the insurance claim itself, and the association should only be out of pocket its deductible. And then the third bucket there is the construction defect items that we're talking about today. And really the key to your thinking here is that with a construction defect, things just never were right from the beginning. Either components or systems or areas of the project weren't properly designed or weren't properly constructed. One key thing to remember here is that with a construction defect, you may not only have problems with that system or component itself, for example, a stucco system, but oftentimes more significant damage or more significant costs of repair arise out of the damage that's going on behind the stucco system, to weather-resistive barriers, to the framing itself, even touching on the insides of units where water intrusion through the outside of the building may be causing mold growth or other damage inside the unit, and that certainly would be within the context of a construction defect lawsuit being handled by or put forth by the association. Ultimately, if you do have these sorts of construction defects and resulting damage, oftentimes, unfortunately, the appropriate and only real remedy is to take little legal action. Robert, getting back to you, since we are talking about different forms of deterioration, certainly with construction defects, we're talking about a much shorter time frame in which that deterioration is occurring. What expectations would you have as a reserve study specialist in terms of construction defects and a reserve study?
Well, I think, Joe, you mentioned it just a moment ago with talking about how reserves are intended to offset ongoing deterioration, not anything catastrophic or the significant problems that you described with the stucco and the underlayment and water prevention barriers, waterproof barriers, things like that, that just aren't to be expected. The ground rules in the reserve study business are National Reserve Study standards, and they say that we are to presume that the assets were properly constructed. So that's our starting point. We are presuming that, like it says in the business judgment rule, the team that the board of directors has assembled, the legal team that the board of directors has assembled for the construction defect resolution, is going to work successfully towards getting the property back to being properly constructed so that we can then guide the association effectively into the future. There's a bump in the road, certainly, but our job is to hold the association's hand and say, it's going to be okay. Let me make sure you stay on track and help you get to the future.
Great. So turning then to just an overview of the construction defect process. We've laid out a few bullet points here for you. With respect to investigation, really two things to keep in mind. There often is a pre-litigation or pre-lawsuit investigation. You would want your construction defect attorneys, along with some of their experts, to conduct that. That would give everyone, including the board and the manager, a really clear view of what the likely defects are, how extensive or widespread they may be, and what they really mean to the association, both in the short and the long term. Then during the course of the construction defect lawsuit itself, there's much more involved and detailed investigation, again, primarily through expert witnesses, not only for the association, but for the builder or developer or other defendants as well. Oftentimes that investigation will extend into intrusive or destructive testing where certain components may be removed. Again, talking about a stucco system, in order to see how that stucco system was really installed, because it involves several layers or components, an expert may want to start cutting small areas of stucco out to see how the different pieces were put together. Were other components that are integral to the functioning of that stucco and keeping water out of the building all installed correctly, both in terms of sequence and overlap and the way that they all play together. That's the sort of investigation that you can expect. And oftentimes that can extend into, again, the interiors of the individually owned spaces. If you have issues that are causing or potentially causing damage within a unit itself, that should be properly investigated as part of the lawsuit. With respect to statutes of limitations and repose, again, these are time limits that can affect an association's ability to successfully pursue construction defect litigation. The statute of limitations is typically the most important and usually the shortest time frame. There are some states in the country that have as short as 2 years from when a defect first shows up or becomes known, within which the association would need to pursue its claim. So an association does not want to sit back after it becomes potentially aware or maybe concerned about issues above and beyond that normal wear and tear. You don't want that time limit to run out and really from the beginning prevent the association from successfully pursuing its claims. A repose is more of a safe harbor, usually a little bit longer time frame. It's normally the limitations period that you want to be careful about. And one way that reserve studies play into that is that they can be potentially good or potentially bad. A reserve study may identify construction defects. They may not be recognized as that at that time, but we've certainly seen plenty of builders and developers use a reserve study to argue that the defects were known well outside of that limitations period. On the flip side, we've seen plenty of good reserve studies that clearly show that the defects hadn't manifested, weren't enough to trigger that statute of limitations. So depending on the circumstances, we sometimes like reserve studies, sometimes we'll have to contend with potentially harmful information within them. That makes it really critical to have a good reserve study provider or specialist working for you. Litigation and settlement, really litigation can be two things, either a trial with a judge and jury or a slightly more informal process known as arbitration. At the end of the day, they're really both handled and approached in pretty much the same exact way. We have found over the years that almost all construction defect cases tend to settle before the trial or the arbitration. That really, I think, is more a function of, it's pretty clear-cut usually whether or not a community has been designed and or constructed correctly. The argument is usually whether the scope of repairs the association's experts have identified is appropriate and reasonable, and then what the reasonable cost of repair is. So that these cases do tend to settle rather than end up in the courtroom. However, it's still a long process. Normally, on average, we're seeing cases taking anywhere from 12 to 24 months to work through that process. And only at the end of that process, when the association has collected money, can it then begin its second phase or second step, which is the reconstruction. And that reconstruction really needs to be managed by experts in the field. Oftentimes, it will be the association's own experts from the lawsuit, but that would include engineers, architects, and repair contractors who specialize in repairing defect conditions in communities that are occupied. Ultimately, it is the association's burden to prove all of its defects and its damages. And in order to do that, you've got to go through this long, detailed investigation and expert witness process. One thing to note is that there are conditions or situations within a defect lawsuit where it's okay to do nothing to the conditions. You may be told by your attorneys to allow damages to continue to occur, or for deterioration to continue to occur. A lot of that just revolves around evidence that needs to be presented, and other considerations, including not wanting to throw money at making a repair or a maintenance that may ultimately be a waste of money because that condition or that component is going to have to be removed or replaced or may become damaged during the defect repair process. In terms of the types of defects to watch for, we've given you a laundry list there of the things that we most typically see in these cases. Building envelope is really the skin of the building. The other ones are pretty self-explanatory. And then the next slide, there are just a few representative photos of some of those conditions. Photographs are very heavily used in these cases to show the judge or the jury or the arbitrator really what's going on, and most importantly, the damage that's occurring throughout the community. And then one other thing I wanted to touch on before handing it back to Laura is this slide here. And this is a little bit outdated, but it shows the number of states around the country that have specific construction defect legislation or laws. And that can be either state or local. And all of those laws need to be complied with either as a lead up to the construction defect litigation or throughout the litigation itself. These can involve notices of claims or rights to repair, where the defendants get the right to come out and inspect and maybe even do repairs of their own choosing. Some of these statutes touch on an association having to vote to approve the litigation. It isn't left just to the board's discretion, but the owners get a say in it. Other state laws that may come into play would be common interest community laws, the Common Interest Ownership Act, for example. Sometimes we see nonprofit corporation or other state laws coming into play as well. One other thing that's important to look at in terms of litigation is the association's governing documents, which Laura has mentioned. Those documents themselves may also include various pre-litigation or actual litigation requirements or restrictions. again, everyone needs to be fully informed about those and make sure that to the extent those do apply, your attorneys and your experts are following the process to the letter of the law. With that, I'll turn it back to Laura.
You know, Joe, that raises the question, which is, okay, if we find that our community is faced with handling or moving forward with a construction defect litigation, how are we going to pay for it? You know, attorneys are known for being cheap, right? Not exactly. So many boards look at it and say, but we can't pay for that. We already have enough problems because we have all these repairs that we didn't expect. And so there are usually 4 ways that the process can be funded, or at least that boards consider funding it. And each of these ways listed: using reserves, imposing a special assessment, increasing just regular assessments, and or hiring a law firm that will handle the cases on a contingency basis, all have pros and cons. I would say that the first 3 probably have more cons than pros, but you boards need to consider these things. You know, using reserves, number one, that's not what they're designed for. There can be tax implications of using reserves to pay for something that isn't a reserve component, but also it is just kind of shortchanging it, and you will then find that boards end up not having sufficient reserves, and so that may not be the best thing. As to assessments, can you get the necessary approvals or not? But using a law firm that does work on a contingency basis, all that means is that the law firm isn't going to get paid any legal fees until it recovers an award of damages and money on behalf of the association, and then it takes a percentage of those. The other factor to consider is not only just the attorney getting paid, but also how is the board going to pay for the upfront costs of the litigation. And those litigation costs can be quite extensive, as they also involve your expert witness fees. And as we've talked about before, having a team and having those experts help you and help your association develop the case, really determine a proper investigation, what is the extent of the damages, is going to be essential. And those costs can run upwards of $100,000 at times. And so a law firm that is willing to front those costs can be a major benefit to an association who's looking at doing some type of construction defect litigation. But the important thing to remember here is that the bills don't stop, right? The regular bills, paying the electricity, paying the water, paying for snow removal, paying for insurance, all of those things continue, as well as the deterioration that you might be having. And so what's really important for the boards to think about here is that you don't want to create future problems. And so, as Joe alluded to, really finding a strong team of experts, I have seen in my practice over the years that is essential, because having those experts will allow your community, your board and your management to really focus on running the operations of the association on a day-to-day basis, and not get hung up in, or not get distracted, I should say, by all of the details of a construction defect suit. It will allow you to have those experts give you advice in terms of caring for the assets. What should you repair? What shouldn't you repair? As Joe's been talking about, how to make sure that you don't spoil evidence, how to make sure that you're going to maximize your recovery. And so just remember that the bills don't stop.
Yeah, Laura, let me jump in and tag on to that. The bills are the operating bills, and often the single biggest mistake we see people making with respect to reserves, and I shared this with Joe back when we were chatting a few months ago, was that associations think that, well, construction defects are happening now. Reserves happen in the future. Let me worry about those future things in the future. But really, it's ongoing daily deterioration, and that cost of ongoing daily deterioration is kind of like water building up behind a dam. It's just a little bit at a time, and if you do have a good team and they're advising you, then hopefully the board can keep their eye on the big picture and remember that, oh yeah, we need to put a little bit aside towards reserves, and so we don't get distracted and let it build up and all of a sudden the dam breaks, and that's what they call a special assessment. And my mom would also always say to me, don't jump from the frying pan into the fire. You don't want to go from one problem to another problem. So if you can do the little things right, then you can avoid just creating another problem in your own future. Well, when you get to, I think it was Loura talked about the 3 principles of success. One of them is managing to stay compliant with state regulations. And you've got reserve study requirements in there, and you might want to think, oh, gee, why am I doing a reserve study if everything's going to change? Well, you do want to have an effective strategy. Some of your assets are going to be affected by construction defects. Some are going to be normal reserve projects. Hopefully your reserve specialist is working with the construction defect team to understand what projects are going to get done with reconstruction funds, because as a wise board member, you don't want to be collecting funds for reserves to replace the asphalt if indeed the asphalt in a year or two is going to get totally rebuilt with reconstruction funds. So you want the timing to work. You don't want to do duplicate funding. The association has so many expenses at this point in time that instead of having a remaining useful life of 0 for the asphalt, the reserve specialist may put together a reserve study that shows that, asphalt's going to get taken care of with reconstruction funds, and so the remaining useful life for the asphalt is 20 or 25 years. And it also means strategic timing. If there's related projects, painting of things that are going to get rebuilt with reconstruction funds, you don't want to paint something right before it gets replaced just because it says so in the reserve study. The reserve study is a plan. Remember, we are putting together that plan based on normal, properly constructed assets, the normal timing of things, and that may require a little bit of adjusting as the reality starts to come into effect. And that's a valuable part of the reserve study, to let the owners know that we are indeed stalling the painting of this, but it's for this good reason. The board is not sitting on their hands and neglecting things. And I just want to make it clear that for those of you who've heard our teaching or the teaching of so many reserve providers out there, there's 3 types of reserve studies. Most associations only need a full reserve study once. And this is one of those cases where that rule doesn't apply. If the association has had some major reconstruction where the roof lines have changed, literally the quantity of asphalt has changed because of turn radiuses or something like that, or even the profile, the composition of stucco versus wood trim or other materials on the external of the building has changed, this may be a time to do another full reserve study after construction defects have been resolved to get a nice clean slate. But there is some value to update with site visit and update no site visit during the potentially multi-year process of litigation, because that does take a while and you don't want to let your budget get way off track.
So what we're really talking about here in terms of the team is providing your associations, your boards, a real path to success in the event you're faced with construction defects. Again, it really requires a balancing of the priorities, and it's certainly appropriate, and we always recommend to our associations that they rely heavily on us and the rest of the expert team that's been put together. The associations need to rely on that team to know which projects they should continue to focus on and fund and actually implement, as opposed to those projects that they should defer or put off until the lawsuit or the litigation is resolved. Now, there will be projects throughout the course of a defect lawsuit that an association has to continue to implement. Again, the goal is to, as much as possible and as best as possible, maintain, protect, and enhance the community, particularly as to those non-defect issues that still are a big component of the community and the association. Certainly expect that there will be communication between your association's reserve provider and construction defect counsel. We want to be talking about the timing of executing reserve projects and really how to reset certain reserve components at the end of a successful lawsuit. I think doing all of that really ensures that the board and the manager are are meeting those requirements of the business judgment rule and doing the best they can for the association.
You know, I think I'd kind of summarize by really mentioning three things. First of all is it's important that board members and managers remember the big picture, and not just to focus on the construction defect litigation if you find yourself involved in it, but also to remember that you have ongoing responsibilities in terms of maintenance, in terms of reserving and fulfilling all of those other duties under your governing documents. The second is remember that you're being watched and that your efforts are going to be measured, and use the principles that we've given you here today in terms of success, but by focusing on complying with your governing documents, the statutes, and the business judgment rule. And then lastly, I would say is to really focus on what you're doing here. You know, litigation is challenging. It's filled with conflict. But the purpose of it and the end result is to really create a better, stronger association that your board and owners are going to want to be a part of. Couple of successes or a couple of tips for making sure that you're successful in that respect is making sure you have a communication plan with owners and that you're communicating openly and frequently, making sure that you are working with your attorney in terms of protecting attorney-client privilege, protecting strategy decisions, but also giving the board or giving the owners information about what's going on so that they can understand that they need to be patient and that litigation, no matter what kind, takes time. And then the other thing I would say is, particularly for managers, is to make sure you have good documentation. Evidence is crucial in any kind of case, but particularly construction defect cases. And so start at the very beginning. Document everything, whether that's photos and minutes, your conversations with developers, anything like that. And then lastly, the tip I leave you with is making sure that you do assemble that really strong team of experts that can lead your board through the process, making sure that you're satisfying the business judgment rule. And I know from my experience that boards who do these things and communities that focus on these successful tips really end up with having a community that looks like this slide as opposed to the pictures that Joe was looking at earlier.
Well, thank you, Laura and Joe, and for everyone listening. I think you have to realize that this is winnowed down. We probably have about 3 times as much material as we shared today. It's great to be able to share some of these tips and just give you an overview of the overall process. The challenges are real, and we wanted to make sure, rather than get into the details of every separate construction defect possibility, that's what your team is for. So we wanted to give you the idea of what success looks like, walking down that path of success, keeping your eye on the big picture. So that wraps up our prepared content for today's webinar on reserve planning and construction defect litigation. To find additional resources, you can go to the Association Reserves website, which is at reservestudy.com, and there you can find some additional written and video articles under the Learning Center. You can request a proposal or join our email list if you want to stay informed of future webinars like this one. And at the Berg-Simpson website, which is very simply bergsimpson.com, you can find a great little case evaluation tool and some additional information on their information tab, and also, at the bottom of the page. So on behalf of myself, Laura, Joe, and the companies we represent, I want to thank you for attending. This indeed is a challenging situation, competing priorities, but there is a success path, and we've hoped that we've shared you enough of the big picture to let you know how you can get on and stay on that success path. So at this time, I'll turn over the microphone to Paige, who will coordinate our Q&A time together. Paige.